Hello, Dan Marr here, talking to you today about what happens with joint bank accounts when you add somebody to your joint bank account. I'm a practicing lawyer here in New Hampshire, Nashua, New Hampshire at Hamlin Carrigan for approximately 35 years, and before that I clerked for the courts for a year learning the litigation routes because I do both litigation and transactional work. And one of the things I've seen as a major mistake with estate planning is that somebody is recently widowed and they need help with their paying of the bills if they're in the hospital or the like, and rather than going through the power of attorneys, there's what's called a durable financial power of attorney that your estate planning attorney can set up for you. You add your daughter or your son or maybe even a neighbor to the account just as an accommodation so they can pay your bills. And that does work for that process of them being able to sign your electric bill and if you have rent or mortgages or anything like that, it helps do that. But the statute itself, the New Hampshire statute, which was prepared for the banking lobby to protect the banks, and understandably so, is if you put somebody just on their account and you don't say anything else in regards to it, you just add them to the account, they can clean it out. Upon death, it goes automatically to them. And so you both own that account. And that's an important consideration because you might be in a situation where you love and trust your son or daughter, but they might have creditor problems. Something comes up, maybe they have some medical expenses that are unforeseen and they're uninsured, and somebody makes claims against their accounts and they go after the assets of them and they make an attachment on this bank. And if they do, you'll have to fight to show in the court that in fact it is your account. Now, I've had success in doing that, notwithstanding the statute, but that's a big issue if there's a lien on the account. Bigger issue is what happens if your son or daughter, something goes wrong in their life and they take the money. They decide to take the money and you don't have the money anymore and you don't have it for the needs that you have towards the end of your life. You need it for assisted living facility or anything else like that, or other situations that you might have. So my strong recommendation is if somebody's not truly supposed to be an owner of that account, meaning that they are free and clear to have that account, don't put them in as joint tenants rights or put them as a joint bank account holder, because then they can clean it out and then all of a sudden death it goes to them. And that might not be your intent either. You have several $100,000 say in a savings account or $50,000 and you plan on dividing it evenly with your 4 children or 3 children, and one of them has their name on the account. It creates confusion, and even legitimately that person that has the name on the account, if you didn't talk to them about that, they may not really understand whether or not that was intended for them. So avoid that issue by going to your bank and also going to your estate planning attorneys. First going to your estate planning attorneys, and if you need one of your children or somebody else to act as your agent, create that agency arrangement with the power of attorney. A durable power of attorney is one that even when you're later incapacitated, you're not capable of making decisions, but you signed it when you were capable of making decisions, that person can still act on your behalf. And they can help you with everything from paying assisted living facilities, doctor's bills, your electricity bills, all of those things. And it's very clear that they're doing it in their agency capacity and not anything more. And so that makes perfect sense. And then you can also go to your bank too, and there's a variety of ways to hold accounts. You can have it payable on death to that person if that's the intent. You can have them as an agent for you and then payable on death. You have a variety of options. You talk to your customer service reps at the banks. I find in my experience with all the banks, they're excellent in regards to that. As long as you clearly explain your situation, you can have the bank account that suits your needs. If you have any questions, you can call our firm at Hamlin Carrigan, and you can talk directly to me or anybody in our estate planning department at 603-883-5501, Dan Marr, 603-883-5501, or contact us at hamker.com, hamker.com. Thank you.